This training will acquaint you with data practices in Minnesota. As a board or council member of a state agency, you have legal duties in regards to government information and records. If you have already worked in Minnesota government or served as a council or board member, you may be familiar with data practices. This will serve as a refresher. Data practices describe how government handles data or information. Let's begin. The Data Practices Act calls for an open government, accountability, and transparency. In Minnesota, this law means everything government creates as part of its official duties is public. For example, your email correspondence is public unless there is a specific state statute or federal law that allows you to protect it from public view. There are three key laws of data practices. They are the Official Records Act, Records Management Statute, and the Data Practices Act. The bulk of your data practices responsibilities are found in the Data Practices Act, but it is important that you are aware of the Official Records Act and the Records Management Statute. The Official Records Act states that all government employees must make and preserve all records necessary to a full and accurate knowledge of their official activities. This means it is the duty of government to create certain records. How a department chooses which documents to create as official records is within the mission and discretion of the agency. To be effective and efficient, government must also destroy records periodically. The Records Management Statute applies to official records as it ends a life cycle. Official records may only be destroyed subject to the statute. As a board or council member, you will want to be aware of your agency's records retention schedule, which lists when particular records may be destroyed. Make sure your board or council has a retention schedule and your staff is aware and complies with it. The Minnesota Government Data Practices Act is in Chapter 13 of the Minnesota Statutes. The bulk of your board or council's government data responsibilities come from this law. Minnesota is unique from other states' freedom of information laws because of our presumption that all government data are public. The only exception is if there is a specific classification in law that is not public. The law also places an obligation on government agencies to protect data classified as not public. Finally, it is important to remember that the Data Practices Act applies only to state and local government entities, not to the legislature or the courts. They each have their own rules. As a council or board member, everything you create and maintain as part of your board or council duties is called government data. According to its definition, government data are anything collected or maintained by a government entity that can be recorded, including paper files, emails, electronic documents, photographs, and maps. The Data Practices Act provides the classification for government data. There are three classifications for data: public, private or non-public, and confidential or protected non-public. Public data are available to anyone for any reason. They are not required to provide a reason for requesting public data. Expense reimbursements claimed for travel expenditures is an example of public data that a state agency may have about you. Private or non-public data are available only to the data subject, individuals within a government entity whose work requires access to the data, other entities that are legally able to access the data, and individuals with permission from the data subject. Names of a government employee's dependents or reasons for using sick time are an example of private data. Confidential or protected non-public data are not available to the data subject. Active civil investigative data maintained by a state agency is an example of confidential data. Data collected and maintained about a board or council member are government data. Some data are public and some are private. For example, your home address is public information. If you conduct council or board business on a personal portable device, like a smartphone or laptop, any related data you create or maintain on the device is government data and subject to the requirements of the Data Practices Act. Also, keep in mind that all council or board-related emails are government data, including those originating from your personal email account. Your agency must appoint a Responsible Authority, or RA, and a Data Practices Compliance Official, or DPCO. The same employee can serve both roles. Refer any questions related to your board or council's data practices policies and procedures to the RA and DPCO. You may also want to ask about your board or council's data, the classifications, and your agency's records retention schedule. The Department of Administration's Data Practices Office offers advice, training, and expertise on Minnesota's government data practices and open meeting laws. Its services include consulting on data practices, technical and policy issues, assisting with drafting data practices legislation, preparing and providing education resources on these laws, and assisting the Commissioner of Administration with statutory responsibilities. Thank you for watching this training video. If you have any data practices questions, contact the Data Practices Office at 651-296-6733 or email info.ipad@state.mn.us. You can also visit our website at mn.gov/admin/data-practices.